Okay, hello guys. So welcome back to our channel. So today we're going to be talking about insolvency, corporate insolvencies in Nigeria. And I think it's important to mention and just to distinguish between insolvency and bankruptcy because some persons use the word interchangeably, and that's very wrong. Bankruptcy essentially applies to individuals. So individuals are declared bankrupt, while corporate entities, corporate bodies are insolvent in the event that they are unable to meet their liability, right? So that means essentially that the Bankruptcy Act, LFN 2004, applies to individuals. So we have to now turn to other laws that talks about corporate insolvency, and that's the Companies and Allied Matters Act, right? So, I mean, let me just quickly mention what the Black's Law Dictionary defines insolvency as. At least at the beginning, I have set the tone or established the fact that insolvent and bankruptcy has to do with individuals who are unable to meet up with their obligations. So, under the Black's Law Dictionary, specifically the 10th edition, bankruptcy is defined as the quality, state, and or condition of not having enough money to pay back what one owes, right? So that's bankruptcy as defined under the Black's Law Dictionary. But today we are specifically talking about insolvency. And thankfully, the Companies and Allied Matters Act 2020 has made very innovative provisions relating to insolvency in Nigeria, and it also makes some rescue provisions under that law. In corporate insolvency, the fundamental question, right, the court would want to answer is whether a company is paying its undisputed debts. Emphasis on undisputed. Section 572 is very key here. Section 572 of the CAMA, right? It provides a statutory test for determining when a company is unable to meet its debt obligations. So you can check out that section, and maybe let me just read it out, right, so that we are very clear. Section 572 says a company is deemed to be unable to pay its debt if A, the creditor by assignment or otherwise to whom the company is indebted in the sum exceeding 200,000 naira, then due, has served on the company by leaving at its registered office or head office a demand under his hand requiring the company to pay the sum due, and the company has for 3 weeks thereafter neglected to pay the sum or to secure or compound it to the reasonable satisfaction of the creditor. B. Execution or other process issued on a judgment, act, or order of any court in favor of a creditor of the company is returned unsatisfied, in whole or in part. Or C. The court, after taking into account any contingent or prospective liability of the company, is satisfied that the company is unable to pay its debt. Now, this particular section pegs the amount owed at 200,000 naira, but it's also important to quickly draw your attention to the Business Facilitation Act, which amends that threshold. So, the Business Facilitation Act has amended Section 575 to say it's no longer 200,000 naira. It is now as the CAC would from time to time specify. And the reason for this is because 200,000 naira may appear much now, but with time, inflationary tendencies, inflationary moves may come and eat up the whole 200,000 naira. So 200,000 naira at that point in time, maybe years to come, may become a very insignificant amount of money. So the Business Facilitation Act has amended that provision to say it would no longer be 200,000 naira, but it will be as the CAC will specify from time to time. Right now, the following actions are used when a corporate body is declared insolvent. So when a corporate body in Nigeria is declared insolvent, these are some of the actions that creditors can take. Number one is the appointment of a receiver or a manager. Receivership is a long established method by which secured creditors can enforce their security. It is actually only available to secured creditors, that is, creditors that have collateral securing the facility or the loan, the amounts they have given out to borrowers. So a debenture holder whose debt is due to be paid becomes entitled to appoint a receiver, a manager, or a receiver manager to enforce the security. The duty of the receiver is to realize the debenture holder's security by receiving rents or profits over the assets of the company and not to manage the affairs of the company. So, receiver's responsibility is to go after the assets, if possible, sell up the assets and get back the monies for the creditor. The manager, on the other hand, has a responsibility to manage the affairs of the company and get the monies out for the creditors that have appointed them. Another step that can be taken is petition for winding up. Winding up actually signifies the process by which the existence of a company is brought to an end. It's like killing a company, right? And the reason why creditors will go that route is because they want to wind up the company, sell the company, take the monies from the proceeds from the sale, and use it to cover up the debt owed by the debtor. And for these, proceedings are brought at the Federal High Court because that is a court that has the jurisdiction for issues relating to the Companies and Allied Matters Act, right? So you can have a winding up by the court, which is a compulsory winding up. You can also have winding up by the company, voluntary winding up. Then those provisions are set out under section 407 of the Companies and Allied Matters Act 2020. Then you also have what we call the company voluntary arrangement. This is a proposal by the directors of a company, the administrator of a company in administration, or the liquidator of a company being wound up to its creditors for a composition in satisfaction of its debt of affairs, scheme of arrangement of its affairs, right? So it's like, it's like a discussion, right? An arrangement, let's manage the situation and all of that. The next point is the appointment of administrators. And that's another step that can be taken. An administrator can be appointed pursuant to an administrative order of the court by a holder of a floating charge or the company or its directors. An administration order may be made by the Federal High Court. Like I said, it is a Federal High Court that has jurisdiction over issues like this. It may be made by the Federal High Court upon application by the company, the directors, the creditors, or any official of the court designated to act as a receiver under the act or any legislation. And that order is made where the court is satisfied that the company is or is likely to become unable to pay its debt. Right? The court actually has wide powers to make any order as it deems fit upon hearing the application of an administrative order. So a holder of a floating charge as against, there's a difference between the floating charge and the fixed charge. We talked about that in the previous video. So the holder of a floating charge over the assets of the company may appoint an administrator if the administrator has given at least 2 working days of written notice to the holder of a prior floating charge, right? Or the letter has that's the holder of a prior floating charge has consented to the appointment in writing. Now, there are other steps that can be taken and are usually taken by the creditors. Is under the CAMA 2020. And the other step would be conversion of administration to voluntary winding up. A company can be wound up if a resolution under section 620 of the act is passed, where an administrator issues a notice to the CSA that the section applies, Upon registration of this notice at CAC, the administrator's appointment will cease to have effect, right? Where the administrator of a company actually thinks that the company has no property which might permit the distribution of its to its creditors, he will notify the CAC of this fact for the purpose of registration, file the notice in court, and all of that. Then he will now send the filed notice to all creditors, that is, all the persons or all the entities that that company is owing, and the company shall be deemed dissolved within 3 months of the registration of the notice, right? Now, another step point is netting. So, netting essentially involves the reconciliation and payment mechanism under which amounts owed between contracting parties are consolidated into single smaller payments from one party to another. So netting is actually used to denote contractual arrangements by which the claims of different parties against each other are reduced to a single balance. So you say I owe you, I say you owe me. So let's say I owe you 1 million and you owe me 800. So we net, the balance is 200. Right, that reduces my exposure while also settling your own exposure to me. So this issue around netting, this provision relating to netting, is actually new. It was just introduced under the CAMA 2020. It wasn't there in the CAMA 2004. Right, netting may also maybe defined as a method of reducing credit and other risks of financial contracts by aggregating, like I explained earlier, two or more obligations to achieve a reduced net obligation. So the provisions of a netting agreement are enforceable in accordance with the terms of that agreement, including against an insolvent party. So this is another step parties can actually take, netting, to reduce exposures and obligations between the debtor and the creditor. There's also the issue or the procedure on moratorium on creditors voluntary winding up in a scheme of arrangement. So another procedure that talking about this procedure, which is available to a creditor under an insolvency arrangement and compromise, is the moratorium on creditors voluntary winding up in a scheme of arrangement. So this provides that no winding up petition or enforcement action by a creditor, whether secured or unsecured, will be entertained against any company or its asset that has commenced a process of arrangement and compromise with its creditors for 6 months from the time that the relevant company, by way of affidavit, provided all the requirements or the requisite documents for such arrangement or compromise has been provided to the court. Right, so this is essentially a step taken to assist the debtor. Under the old CAMA, it appears to be that once the debtor is unable to meet its debt obligations, the company is more or less going to die. But what the new CAMA 2020 is trying to do is to say, look, we know times are hard, life happens. So if a company is unable to pay its debt, let's find some measures to see if we can salvage the company, to assist the company. Those measures are some of the things I just explained, and it's important to really understand them. And to get fuller details, you can read through the Companies and Allied Matters Act, the provisions relating to corporate insolvency. If you have further questions, you can just drop them in the comment section, and please don't forget to like this video and subscribe. It means a lot to us that you subscribe. Thank you very much. Have a wonderful day.